morning. For those of you who don't know me, my name's Eloise Scotford. I'm the Dean of the Faculty, and it's my absolute pleasure to see this room and this lecture theatre so full and to welcome all of you to this year's Bentham Association Address. Provost, council members, colleagues, alumni, students, visitors from other law schools and other guests. Tonight, and there is our chair, this just remarked to me, there is an air of anticipation in the room, and that is because this is a very special edition of our annual flagship alumni event on at least 4 counts. So first is the 75th Bentham Association Address. I think before you get to 100, 75 still counts as quite an important milestone. The Bentham Association was founded by our alumni in the faculty as an alumni club, with an annual address delivered at UCL by a nominated president for the relevant year, who is an accomplished lawyer, usually with some connection to the faculty, and the list of past presidents includes many of the great and good of legal academia and the profession in the UK and abroad. This year's president, whom Professor Sands will introduce shortly, very much continues that esteemed tradition. And for alumni who regularly attend this event, and those coming back to Bentham House for the first time in a while, you are very welcome. It is also our UCL 200 Bentham Association Address, and this evening launches our UCL 200 programme of events in laws. Last Wednesday marked 200 years since the founding of UCL. For some of you may have come, there was a spectacular sound and light show in the renovated quad. I recommend having a look at the quad. I've just been this evening at the launch of a fabulous exhibition for the university in the Wilkins building in the Cloisters, which is worth a look. And for those coming to dinner, please do come and have a look at that. I should note, many of you will know our former Dean, Dame Professor Hazel Genn. She has been Provost Bicentennial, leading the Bicentennial celebrations for the university. But in laws, we are also claiming that 2026 is 200 years since our inception, not of the faculty itself, but through the creation of inaugural chairs in 2026, even if appointed in 2027. And here we get into questions of what year the faculty was founded. And that element of historical detail and query aligns with the third special limb of tonight's festivities. It is also a special event for the faculty's Legal History Research Group. The faculty has a strong and proud tradition in supporting the research and teaching of legal history, and we are also delighted to welcome very eminent legal history colleagues from other law schools this evening. And finally, it is the unofficial, you will have noticed upstairs a book on sale, it is the unofficial launch of a book that combines all three of those special features of tonight's events. The second edition of The History of UCL Laws, which was made possible by an alumnus and features many of them, has been written by legal academics. The first edition written by Sir Julius, I've just knighted Sir Julius. And I haven't actually met Julius, but I think you're in the audience somewhere. Can you wave your hand? There you are. Hello.
I'll take the knight.
I know, I just knighted you. Oh, God, sorry. Dr. Julius Grower. And it was first written, the first edition, when we moved back into the newly renovated Bentham House. And the work on updating the second edition for this year was by Dr. Peter Leith. And it has been published to celebrate our bicentennial. At the beginning of our bicentennial year in the faculty, this evening we are looking back to where we began. And our president will help us more with that task this evening. This faculty has very important roots. Like any organisation, the history of our faculty has had twists and turns, phases of power, politics, personalities, great highs, great challenges, but there is, as there is for UCL, a strong origin story of values and purpose that have defined a whole institution and this faculty from its inception, which has provided both a guiding compass and a recipe for its success. UCL's founders, setting up a radical higher education institution in opposition to the Oxbridge model, believed in promoting academic excellence through equality of opportunity, where education should be available to all, regardless of background. It is no surprise that the first black man, indeed who was born a slave, to receive a law degree, Sir John Carr, I'm knighting everybody, achieved that degree at UCL in 1831. The first Jewish man to practice at the bar, John Simon, read for his LLB at UCL in 1841. The first woman to receive a law degree, Eliza Orme, was educated at UCL. The first Chinese man to receive a British doctorate in law Cheng Tianxi received his doctorate in 1915, and so on. The faculty has been a magnet for groups traditionally excluded from the legal profession and for students and staff from so many countries and backgrounds since its founding. Some of you, I know, will remember the Bramshill Police Scholars as a notable example of the widening participation in the faculty. And we have been and are hugely successful in teaching and research excellence and in producing rigorous and useful legal knowledge about laws and legal systems in the service of society. We do believe that this success and this approach to inclusion are related. It's a wonderful story to tell as we celebrate 200 years, and it continues to motivate our work in the faculty today. One important element of that work is our inclusive law school mission and campaign, which expresses our foundational values in today's setting. To that end, I am really very proud that as a faculty we provide mentoring and support for sixth form students from disadvantaged backgrounds interested in applying for law through our Target Law initiative. We offer opportunity scholarships on all our degree programs to students who face financial barriers to study, with some dedicated UCL 200 opportunity scholarships this year, with philanthropic support from the Vincent and Sissy Chu Foundation and other generous donors. We provide additional support with study skills and in-kind support during the studies of our students through a student success program, and we've been expanding our offering of internships for students, which can be life-changing and are just good for learning how to be a lawyer. And we provide backup support for students facing financial strain through our hardship fund. Now, in delivering on that mission, which is a really tough thing for us to do, but we prioritise it, our alumni play an incredibly important role. And I want to note how much we value our alumni, your advice, and the incredible support that you give to the law school in so many ways, as well as how proud we are of your achievements. For all alumni this evening, I have a few notices, and I just want to flag these. Have a look at our events programme. There are flyers. There's a digital hub on our website, which we're very proud of. And mark your diaries, please, for our first ever alumni weekend on the 8th to the 10th of October. Lisa Penfold, who you all know, is definitely in charge of that one. There is something for everyone. You can register your interest on the Law's website. Finally, some thank yous. Professors Prince Saprai and Virginia Mantuvalu for championing UCL 200 in laws and leading our UCL 200 events programme, respectively. Dr. David Foster, and I saw you before, but now I've lost you. Where are you, David? There you are. God, what are you doing up there with us? For the legal history collaboration, Julius and Peter for the wonderful book of our history, which is available for sale upstairs to support the Inclusive Law School campaign. And for making this evening happen, a host of superb professional services colleagues in our events team, our comms team, and the wonderful Daisy Shelton, who leads on our special projects. It is now, with that long introduction, my pleasure to hand over to my colleague Philippe Sands, UCL's Professor of the Public Understanding of Law, who will also be delivering two brilliant events on this year's UCL 200 events programme. Philippe arrives in the faculty fresh from the International Court of Justice, where he regularly appears, this time acting for the Gambia in a landmark genocide case, and he has his own passion for legal history, literature and public international law, which his well-known books beautifully illustrate. He is very well placed to chair this evening's lecture. Thank you, Philippe.
Thank you, Eloise, and so incredibly nice to see so many familiar faces and an absolutely heaving room. It falls to me to introduce Sir John Baker, who is very closely connected to UCL, as many of you here will know. It's almost impossible to imagine any individual who would be better placed to introduce UCL's 200th anniversary, the 75th Bentham Association annual presidential lecture than Sir John Baker. He was a student here from 1962 until 1965. There are people in the room who were students with him, and you are, of course, especially and very warmly welcome. He then taught here as a lecturer before moving up to Cambridge University where for a short time he was, I think, the librarian at the Squire Law Library, and a fellow at St Catherine's College, and eventually appointed as the Downing Professor of English Laws. And he has had multiple appointments around the world. We interacted in some of those appointments. He is a fellow of the British Academy, a fellow of the Royal Historical Society, an honorary King's Counsel, and also, according to Wikipedia, so believe it or not, the only person in the history of this country ever to be knighted for services to legal history, which is really a very wonderful thing. Many of you are familiar with his writings and his books. I am, because I was a student at Cambridge University. Eloise was saying before she moved to England, the one book she turned to before coming to England for the first time was John Baker's book on English legal history. The relationship for me is not purely a UCL one, however. I was an undergraduate at Cambridge and was taught by Dr. Baker, as he then was. In my LLM year, 1982 to 1983, I and three friends decided that we would not live in college. We rented a house on wonderful Hurst Park Avenue and were absolutely horrified to discover that our next door neighbour was John Baker. Which meant that we had to behave ourselves with rather more decorum than we might otherwise have done. 2 years after that, I had the great happiness of being appointed a research fellow at St Catherine's College and shared 4 years of my academic life with John Baker. And many of you know this. He's an extraordinary colleague. I mean, he's generous, he's wise, he's curious, and for a young academic, even working in a different field, I still to this day feel I benefited from the occasional lunches he would invite me to, as the world right now is in such a difficult place and a difficult moment. I'm often asked by students, and when I do public events, how I keep going in relation to international law. And John knows this, so I don't want to overly embarrass him, but I cite a conversation that I remember myself having with him over lunch back in the 1980s. He would invite me occasionally as a kid in your mid-20s. One of the most exciting things was to be invited for lunch at St Catherine's by Dr. Baker. And he would always ask me what I was working on with Elie Louterpact, and I would sort of summarise what I was working on, and he would then, as he does, as you know, stroke his beard, and he would say, ah yes. We had a problem like that in English law in about 1472. and it took 275 years to sort out. And of course, that's where international law is today. And so I draw solace from the wisdom of John Baker, my colleague, my teacher, my friend. And it's an extraordinary happiness to introduce him now to deliver this lecture and really to open UCL's 200th anniversary in the law faculty. John, the floor is yours. You are so welcome.
Well, thank you, Philippe, for that undeserved introduction. It's very kind of you. It's a pleasure to be back. And I'm deeply honoured to serve as your president this year, since it's such an auspicious time. I owe to this my alma mater the whole course of my adult life. I mean, Dennis Holland, and I think those are meant to be representations of him up there, was brave enough to take a gamble on admitting me. And George Keaton took an even braver gamble when he offered me an assistant lectureship before I even had a degree, without any application or interview. Such things can't happen anymore. I'm in two minds whether to regret that or not. But they started me on a career which I would have never foreseen. And so I begin by recording my gratitude to them and to my teachers and former colleagues, some of whom are here. But that's not the subject of my lecture. I was asked to say something about the college history, so I will begin with 1826. And that is now taken as the date of foundation, although the first centenary was celebrated in 1927, and some reckon the true date as being 1828, when the buildings were sufficiently underway for teaching to start. But as Eloise said, 1826 is the correct date because 200 years ago last week, the deed was executed, which established the college as a joint stock company. Among the subjects whose study was deemed from the start to be essential was English law. And no doubt Lord Brougham was behind that. At Oxford and Cambridge, the only courses on English law were extracurricular. And after Blackstone's highly successful beginning, were very poorly attended because students preferred to read Blackstone. And in both universities, the professors of English law had given up lecturing altogether for want of students. I mean, many great lawyers did attend university before 1826, but they didn't acquire any formal legal education before entering the Inns of Court, where the ancient degree of barrister at law was earned chiefly by eating dinners. Moreover, there was no admission for anyone who didn't conform to the Church of England. And the new university was intended as an escape from that. Cuncti ad sint was the motto, let all come. It couldn't grant degrees, since degrees were deemed to be titles of honour derived from the Crown, but the University of London, as incorporated in 1836, was given that power by its royal charter, and the first 3 LLBs were awarded in 1839. As Eloise mentioned, one of the first batch, as Andrew Lewis discovered, was a former West Indian slave. Obviously, a Georgian Dennis Holland was at work there. But what a way to start. Our first law professors were Andrew Amos, Professor of English Law, and John Austin, Professor of Jurisprudence and the Law of Nations. And I outlined their story half a century ago on the occasion of the 150th anniversary. And I hope there's no one here who remembers it, because I plagiarized a bit. Yeah. But, as I was saying 50 years ago, the professors faced a novel challenge, but they approached it very differently. Amos was a common lawyer, while Austin breathed the foggier air of the Chancery. Amos enjoyed the cut and thrust of trials and argument, while Austin taxed his brain with contingent remainders and executory devisers and all that sort of thing, and was becoming bored stiff by the drudgery of complex draftsmanship. Perhaps surprisingly, it was Amos who had enjoyed a distinguished academic career, having been one of the best mathematicians of his year at Cambridge, whereas Austin didn't attend university at all. Austin had in fact spent his formative years as a lieutenant in the British Army, and yet he was the one who seemed more naturally inclined to the intellectual life. His re-education was nurtured in Queen Square, not the one in Bloomsbury, but the one off Birdcage Walk, where he lived near J.S. Mill and Jeremy Bentham. And before his appointment, he and Mill had taught themselves Roman law together, reading. And before beginning to lecture, Austin had visited law schools in Prussia to find out how they did things over there. And he was delighted to find out that the German professors paid little or no attention to the actual law of the country. Austin concluded that students would cope better with their English legal studies if they could fit the details into a universal pattern of basic concepts like law, right, obligation, injury. And his core theory that law could only be understood as a command from a superior, perhaps influenced by his military experience, hasn't been universally admired. But the late Professor Twining considers his lectures the greatest single contribution made by University College to the study of legal ideas, bestowing on him the somewhat tepid praise that he was a poor man's Jeremy Bentham. Now, Amos's approach could not have been more different. despite his background in mathematics and classics as a fellow of Trinity, he was more down to earth than Austin. He regarded English law as deeply rooted in its history, without which it couldn't be understood, and he produced a new edition of Fortescue's De Laudibus Legum Angliae for Butterworth's in 1825. His lectures, he announced, would be illustrated by examples drawn from recent cases, which the students might have heard about. He was an enthusiastic and painstaking teacher who organised legal conversations, something like supervisions or tutorials. He invited eminent guest speakers, encouraged the students to form a debating society. He arranged voluntary examinations to encourage effort, and he rewarded the top men with prizes paid for out of his own pocket. And he confidently told his class that winning one of his prizes was a very good way for a struggling bar student to attract notice. Well, both lecture courses have survived in full, and they each provide a striking contrast with Blackstone's. Amos's idiosyncratic method is evident from his published syllabus. The first lecture began, rather eccentrically you might think, with a topic of maritime accretion. And then he plunged into deeper water with the feudal system, future interest in land, and eventually, presumably somewhat late in the evening, the history of the forms of action, illustrated especially by the writs De Ventre Inspiciendo and De Pipa Vini Carianda. And the explanation for this seemingly random set of topics is that they were all related to recent cases in which legal history had proved important. The lesson seemed to be that nothing was too obscure to be useful. But that was merely to grab the students' attention. Amos understood what would engage the law students' curiosity, and he interacted with them, encouraging questions and debates. And we're told that his lectures drew packed audiences, well over 100 at first, mostly article clerks and bar students, for whose benefit they were given in the evenings. And he was such a popular lecturer that when he left, his former students presented the marble bust, which I'm sure you all know. It sits in the alcove next to the entrance to Bentham House. I don't think any other law professor here has been similarly honoured. In fact, not many elsewhere except in Bologna. Austin, on the other hand, had none of his colleagues' classroom flair. His syllabus was austerely precise. His lectures were demanding. Tortured by self-distrust and perfectionism, he was prone to neurotic illness, which often prevented him from speaking at all. He was considered to be witty and eloquent in conversation, but his lectures were pedantic and repetitive, owing something to the style of the equity draftsman, I suspect. And he spent part of his inaugural lecture explaining, with much nervous hesitation, the difficulty of giving an introductory lecture on jurisprudence, and his full expectation of chilling indifference, his words, chilling indifference from the students. Well, this successfully persuaded a large part of his class to prove him right by not coming back. The financial consequences were serious because professors were paid from students' fees. There's £4 per student from Austin, £5 for Amos. Shows how they valued jurisprudence compared with law. Well, after only 4 years of struggling with diminishing classes, Austin resigned. But his failure should be seen in context. In 1833, the Law Society and the Inner Temple both instituted courses of lectures closer to the heart of legal London. And the competition had such a serious effect on enrolment at London University that Amos also decided to resign in 1834, and their immediate successors all quit for the same reason. Now, Amos and Austin had each tried to work out from scratch how a university law school should teach law, and they laid down the two threads which still run through academic legal education in this country. On the one hand, a solid grounding in English law and its history, and on the other, a more philosophical and critical understanding of the law's concepts and objectives, and some comparison with other legal systems. These approaches are not in conflict, and both Austin and Amos believed they could be intertwined. Austin said he wanted to train a theoretico-practical lawyer, while Amos hoped his students would see the law not as a mere instrument of litigation, but as a transcript of those eternal principles of morality and justice which bind together families and commonwealths and the great community of nations. But both experiments seemed at the time to have failed. There were no students. Most students just wanted to obtain their qualifications as easily as possible and to learn enough law to spot a legal problem and know where to look for an answer. How different from today. Peter Stafford Carey, in his inaugural lecture of 1839, put this down to, I quote him, the English turn of mind, which exhibits on one side good sense and practical ability, on the other, the absence of general ideas and elevation of mind on theoretical questions. And Carey's successor in 1845 began by begging students to submit to the drudgery of lectures as a means of avoiding the pain, difficulty, and humiliation of having to acquire the same knowledge later in life. Not perhaps the most enticing invitation. Law teaching was sailing into the doldrums, and it almost sank. There were some able professors, including Sir Frederick Pollock, who only stuck it for 1 year, and the future Lord Justice Scrutton. But for over a century, the numbers never again matched those drawn by Amos in the first year or two. And this begat a certain lack of self-confidence. When Alexander Murison became Professor of Roman Law in 1883, he found the administration decidedly slack. No one had told him what his duties or remuneration were to be, and he only found out subsequently that he'd been appointed for life. No one welcomed him. In his own words, I got hold of a beadle who showed me the way to my classroom. There I found waiting for me 2 students. It seems the class had dwindled from 15 during the tenure of his predecessor, Edmund Robertson, later Lord Lockheed, who had spent most of his time in America running the Oregon Railway. I mean, there was some intellectual compensation for Murison in that the 2 students waiting for him were John Salmond, whose textbook on tort we were still using when I was a student, and the future Lord Amelry, first president of the Industrial Court. But the low numbers still didn't provide professors with a living. And it wasn't until 1914, after the law faculty had separated from arts, that the 3 London colleges got together and entered into a joint agreement for law teaching, and Murison and the others were at last paid a salary of £200. And by 1931, when George Keaton arrived, student numbers in law had reached 100, but as he told me, the law faculty only had 4 officers in Crab Robinson, wherever that is, and a fantastically bad library. Even so, the quality of some of its students over the previous century speaks of some success. They included a Master of the Rolls, Cousins Hardy. Jessel was also at UCL, though he didn't read law. A Lord Justice of Appeal, Scrutton. Another one, Fry, who didn't read law. A High Court judge, Wills. A number of overseas judges, including Salmond, the first Jewish sergeant at law, and a Home Secretary, Henry Matthews. They're all connected by the fact that they were ineligible for the older universities. Cousins Hardy was a Methodist, Jessel and Sergeant Simon were Jewish, Matthews was Roman Catholic, Wills was Unitarian, Fry a Quaker, and Scrutton came from a Congregationalist family. I'm not quite sure what he was himself. The religious disabilities in other places were eventually removed by statute in 1871. But it took a little longer to overcome exclusion based on gender. As Eloise mentioned, the first woman to graduate in law here is reckoned to be Eliza Orme in 1888. And she actually went on to serve a pupillage and did deviling work as a conveyancer. But of course, she couldn't be allowed to practice at the bar in those days. Still, UCL led the way, 60 years ahead of Cambridge. Cuncti ad sint. over the last 100 years, the law faculty, as we all know, has enjoyed an upward trajectory. But I used up my first half hour, I think, and I don't propose to talk about the college anymore because I've decided to emulate the meandering approach of Amos, whose Cambridge chair I later occupied myself, and wander back a little further into the past and reflect on some of its resonances with the present. I can sense the suppressed groans at this point. What's the point of legal history? I'm sometimes asked. The past is surely dead. That's perhaps the legacy of Austin and Bentham rather than of Amos, the notion that law can be understood simply in a metaphysical dimension without reference to time or place. But it could all be put into a code of abstractions which would work as well in France or Russia as in England. But I would suggest that the past is no more dead than the future. The common law is a living organism which develops by dealing with age-old problems as they constantly present themselves in new ways. It's a body of accumulated experience. Now, anyone who reads newspapers can see that we've certainly not reached the end of history. Wish we had. Many alarming threats to constitutionalism in the world, some of them in countries we used to regard as civilized partners. Could anything similar happen here? Some of the machinery is already in place. For instance, the Civil Contingencies Act of 2004, introduced by Mr. Blunkett, provides that emergency regulations may make any provision which the person making the regulations is satisfied is appropriate for the purpose of preventing, controlling, or mitigating any aspect or effect of the emergency, and that they make provision of any kind that could be made by Act of Parliament for the requisition, confiscation, or destruction of property with or without compensation, and the prohibition of movement or any other activities. And they may create an offence of failing to comply with the regulations, and in doing these things they may disapply or modify any other statute. In other words, absolute power is available under our present law to a minister making such regulations. Now, it is at least limited to emergencies. Now, we would obviously need drastic emergency action in the event of a nuclear attack or a foreign invasion. But emergency is defined much more broadly in the Act. It could include an event or situation which threatens serious damage to human welfare by causing or involving damage to property, disruption of a supply of money, food, water, energy or fuel, disruption of a system of communication, disruption of facilities for transport or services relating to health. So would that cover, for instance, strikes by medical, nursing personnel, transport personnel? If deemed, they'd have to be deemed serious enough. But that measure was based on the Emergency Powers Defence Act of 1939, but it goes a good way beyond what was deemed necessary as World War II approached. And the Act gives ministers power to extend it further if it doesn't go far enough. And as I'm sure you all know, similar legislative powers are creeping into other statutes in what are wrongly called Henry VIII clauses. Nothing to do with Henry VIII. They're actually first found under Queen Victoria, dear old Queen Victoria. Henry VIII wanted the power to change law by proclamation, which would have had to go to the Privy Council, but still it's the government. And the House of Commons refused. They said, you can make proclamations to tell people to observe the law, but you can't take away their property or lives or rights but by proclamation. A notorious example of this new kind of clause is the power to change the law section in the Banking Act of 2009, which empowers the Treasury by order to amend the law to enable its new powers to be used effectively, including power to disapply or modify the effect of any provision of any enactment. That's a pretty sweeping power to give a minister. And the Constitutional Reform and Governance Act of 2010 likewise empowers ministers to make any provision they consider appropriate in consequence of any provision of the Act. And this can include amending, repealing, or revoking any other act. And one could go on and give other examples. The Children Act of 2016, which is Conservative government, it's not just Blair's government responsible for these, was criticised by a Lord Judge at the time as being entirely an enabling act, not laying down any principles at all, but merely giving ministers wide powers to make up the law when they felt ready to do so. And minor amendments to primary legislation by ministerial order are in fact now of everyday occurrence. But I draw attention to these wider powers as being already there, even if they haven't yet been used. Now, I'm not suggesting that such provisions have been misused as yet, though similar powers have been invoked to undermine the rule of law in other countries. Nor am I suggesting that the driving force behind them is necessarily a growing taste for authoritarianism. It may just be the inbuilt mindset of draftsmen to create powers as broadly as possible and see if anyone objects. That is what I originally wrote. But on Monday there was an article in the Times by a special advisor in which he wrote, where there are roadblocks, ruthless use of emergency legislation, amendments, and a programme to cut back judicial review must be de rigueur. So it really is very much in the mindset of our unelected policymakers. Well, in the past, the House of Commons was the means by which governments could principally be kept in check. It was the Commons which insisted on the proviso in Henry VIII's Statute of Proclamations, which prevented him from using them to affect anyone's life, liberty, or property. Many kings tried to manage as long as they could without parliaments, relying on prerogative powers. But since the law wouldn't allow them to raise money by and large without parliamentary approval, they were forced to summon parliaments and accept the consequences. But that's almost the reverse of the world in which we now live. Parliament is in almost constant session and has become the means through which governments exercise their powers. If a government can't persuade Parliament to enact what it wishes, it's supposed to resign. And it's true that effective challenges can still sometimes be made to unduly sweeping powers, but they're effective only if the government or the press can be made to see the point. So we have what Lord Hailsham called an elective dictatorship, albeit only for a term of years at a time. So one does wonder sometimes whether those powers couldn't be used to extend the life of the Parliament. It's happened elsewhere. Now, there's said to be nothing which cannot be done by Act of Parliament, save for limiting the power of Parliament itself. This was once explained on the ground that everyone was represented in Parliament, even if they had no vote, and was therefore stopped from objecting to its acts. That was a principle of law, albeit bordering on fiction, or perhaps actually fiction. Now it's simply a matter of dogma. The sovereignty of Parliament is somehow a given, the indisputable basis of the British Constitution. Now, if it is indeed a fact, rather than a principle of law, then obviously it leaves no room for judicial control, since it gives Parliament the de facto power to overturn judicial decisions and direct the courts what they can and cannot decide. An extreme recent manifestation of this is the Dissolution and Calling of Parliament Act of 2022, which was necessitated by the repeal of the Fixed Term Parliament Act of 2011. It was necessary to reinstate the royal prerogative of dissolution. But stung by the decision of the Supreme Court in Miller 2, the government decided to introduce a prerogative immunised against judicial review. And Section 3 provides that no court or tribunal may question A, the exercise or purported exercise of the prerogative powers of dissolution and summoning of parliaments, or B, any decision or purported decision relating to those powers, or C, the limits or extent of those powers. So that creates the most extensive royal prerogative ever devised far beyond anything the common law would have tolerated, and is a most dangerous precedent in my submission. I mean, what if a government, upon a dissolution, instructed the Lord Chancellor that no writs of summons for a new Parliament should be issued for a year? And if a year, why not 5 years? That seems to be clearly within the scope of that clause. Could that really not be the scope of judicial review of some sort? So in the light of all this, and contemplating a political climate which one hopes will never arrive, in which a government might actually want, like James I and Charles I, to rule as far as possible without accountability to Parliament or the courts, I would just like to draw attention to a historical analogy. Not a precedent, it's an analogy. If we travel back to the 16th and 17th centuries, the principal constitutional concern was not the sovereignty of Parliament, but the prerogatives of the monarch. Many of those prerogatives were absolute, and some of them still are. They could at that time be used to establish tribunals with extensive jurisdiction, to privatise government for profit, and to raise money short of taxation, for instance by creating monopolies. And the judges of the Elizabethan period faced these powers head-on and brought them under judicial control through the medium of habeas corpus, which they developed at that period and for that purpose. It was one of the greatest achievements of the early modern common law and helped ultimately to save us from a root and branch revolution of the French kind. The foremost champion of the rule of law was Sir Edward Coke, first as Attorney General under Elizabeth I, and then as Lord Chief Justice under James I. He held that prerogative courts and many prerogative acts could be reviewed by the King's Bench because he'd exercised the King's ultimate prerogative of doing justice. And so it wasn't possible to shelter behind the royal prerogative if it was challenged. But what about Parliament? Coke was a former Speaker of the Commons, and he subscribed to the basic notion that Parliament was transcendent and absolute. Those are his words. But he didn't regard that as precluding judicial review of a kind. In his report of the well-known case of Dr. Bonham in 1610, he went so far as to declare that the courts could adjudge acts of Parliament to be utterly void, for when an act of Parliament is against common right or reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void. It's equally well known that all our law books regard that as an unacceptable statement of English law, and it's also been pointed out that none of the other judges in the case even addressed the point. It was either an obiter dictum or an afterthought when Coke was writing his report. And the Lord Chancellor at the time objected. When the King, the Lords and the Commons have spent their labours in making a law, then shall 3 judges on the bench destroy and frustrate all their points because the act agreeth not in their particular sense with common right and reason? The answer then and now must be, of course not. And I'm not going to suggest that Coke's wording does represent the law exactly, but it's worth looking into the logic underlying his characteristically robust language. Coke was not the first judge to treat statutes contrary to reason as void. Now, to us, void is a strong word which imports a lack of legal validity. It means a nullity. But its primary meaning was emptiness, an absence of content. And in this context, it could mean an absence of content to which legal effect could or should be given. Now, the idea that acts of Parliament might be void, in that sense, was discussed as early as 1529 in a Gray's Inn moot, and it was stated in Plowden's reports in the 1550s that a statute could even be read contrary to its wording when it was against all reason. And this was because statutes had to be interpreted according to the presumed intention of the makers. Still says that in the books now, doesn't it? And one couldn't presume that members of Parliament were so stupid as to enact something obviously absurd. it doesn't, in theory, impugn the validity of an Act of Parliament to say that it lacks any meaning which can be given sensible effect. It's just ineffective, in the same way that a statute which has not yet been brought into force is ineffective. Likewise, if two provisions in the same Act directly contradicted each other, at least one of them must be disregarded. It has to be. And so it is in that sense void. Coke thought the same applied to obvious errors. He gave the example of a statute, a rather extreme example, of a statute which carelessly provided a punishment for everyone who did not offend against a statute. That, he said, would be against reason and therefore void. Moreover, statutes can only change the law. They can't change facts. Coke once said that Parliament could do anything except make a woman a man or an infant a man, though it could make an infant of full age. Now, of course, Parliament did alter the age of majority as from 1970, making infants of 18 to 20 instantly of full age, and it has now allowed women to become men in some respects. But Parliament still cannot alter a person's age or chromosomes. It can only enact that they don't determine adulthood or gender for legal purposes in the way that they used to. And that was Coke's point. And for the same reason, whatever political parties may claim, an Act of Parliament cannot create happiness or goodness or produce wealth which isn't there. However much it may claim to do so, no amount of deeming can possibly alter the facts. And such a provision, in that sense, is void. It has no meaning. Now, of course, the difficult question, which I'm coming to, and I'm not going to be able to answer it really, is whether the notion of ineffectiveness by reason of factual or linguistic impossibility or absurdity can be extended to legal absurdity or incongruity. Now, that was what they were discussing in Gray's Inn in 1529, actually. Coke thought it could. And in Bonham's case number 1, 1607, which I discovered in a manuscript only a year ago, he admitted that Parliament could, by clear express language, confer validity on an unlawful royal charter which encroached on the liberty of the subject. However, he said, if for want of sufficient foresight and penning, an act cannot be put into execution without manifest wrong and injustice, then such imperfect act is in judgment of the law void and of no effect. He was thinking in that case of a power to fine without observing the requirements of natural justice. And his proposition can be reconciled with parliamentary democracy under the head of interpretation. Indeed, there are recent judicial opinions to much the same effect, although they don't any longer use the word void. Now, in taking on the king's prerogative, Coke relied on legal history. His legal history was not quite the same as historians' history, as historians are fond of pointing out. It was an intellectual interpretation of the past. He held that the common law must have preceded monarchy because the law determines who shall be king and what powers he has. Now, whether that's historically true is neither here nor there. And logically, there could be a de facto kingship before the law defined its limits, though it would be a kind of dictatorship. But it's equally logical to argue that any idea of constitutional monarchy must be predicated on the prior existence of a concept of law which can define the extent of regal power. In the words of Chief Baron Frey in the time of Henry VI, the law is the greatest inheritance which the king has, for without the law there will be no inheritance and no king. Words which I remember the late Queen quoting when she opened the Queen's building at the Royal Courts of Justice. So she'd been reading the yearbooks. It was on that basis that Magna Carta was accepted as a declaration of the common law. If it had simply been an ex gratia grant of something which the people didn't enjoy previously, that tended to prove that at root we had an absolute monarchy which a bad king could resume. Instead, as a declaration of fundamental common law, it justified the development of judicial review of the prerogative 300 or 400 years later. Now, of course, no one had thought of habeas corpus in 1215, and Coke never pretended that anyone had. It would be absurd. But it was the only way of giving legal effect to a statute which was clearly meant to be serious and didn't specify a remedy. And history showed that king after king had formally confirmed the Great Charter so as to create an indelible understanding that the king, the government, was under the law. Now, the question which I'm not answering is whether the arguments which Coke used to justify judicial review of the king's executive prerogative might ever be deployed to justify judicial review of the king's parliamentary prerogative, that is, the prerogative to legislate with the consent of the Lords and Commons. The executive prerogative may once have been seen as an unalterable fact, a given, that residual part of the king's de facto power on which the law did not trespass. But lawyers such as Coke turned it into a legal concept. The king, wrote Coke in 1610, has no prerogative but that which the common law allows him. Words quoted in Miller II, in the divisional court. Could that also be true of the king's prerogative to legislate through Parliament? If the supremacy of Parliament could be seen as deriving from the common law rather than as an incontrovertible fact, it would not be outrageous for the highest court to declare that there were certain vires determined by the law. That must at least be true of interpretation, because all statutes are mediated through the courts if there's any question about them. And the intention of Parliament is obviously a fiction, and so it is necessary for the common law to determine how that supposed intention is to be ascertained, including the use of presumptions derived from legal and constitutional traditions. Now, of course, going back to what the Lord Chancellor said about Coke, it would be unthinkable for a few judges to undo the deliberations of members of Parliament acting in accordance with their democratic authority. I'm not hinting at that. But there might be cases where some aspects of an ill-considered statute were so inconsistent with basic concepts of justice that the great powers conferred by the electorate on Parliament had been exceeded. A little step has already been taken in relation to Henry VIII clauses. If an order is made under one of those clauses to amend a previous statute, that in effect results in a change in the statute book, even though laying the order before Parliament is little more than a ceremony. So the amendment becomes, in a sense, part of the Act, and it's so treated in online versions. It would be very misleading if it weren't. But there's no amendment of the Parliament roll containing the original Act. The amendment is contained in a statutory instrument, and the Court of Appeal confirmed last year that such an instrument is subject to judicial review, so that the amendment could be struck down as ultra vires, the enabling power. And the sort of presumptions which are applied in striking down such a clause would be very similar to those suggested by Coke. And the effect is as if the amendment had not been made. In that case, therefore, we have judicial review of an Act of Parliament, a power to declare a purported statute void. Now, of course, the courts are said to be prevented from doing the same with primary legislation, because A, what Parliament does cannot be ultra vires if there are no vires, and B, it would impeach proceedings in Parliament and therefore infringe parliamentary privilege. But are there really no common law limitations? Suppose Parliament enacted that a named person should be executed without trial, and that this should not be questioned in any court of law, and that the Human Rights Act should not apply. Would the courts be powerless to modify the operation of such a statute? Most authorities would say yes. And that was also Coke's view, as a matter of fact. Commenting on the fate of Thomas Cromwell in 1540, he wrote that an attainder and execution without trial was lawful if expressly authorised by Act of Parliament, but it was nevertheless wrong, and he felt sure it would never happen again. So if a statute truly appears to be the will of the people, embodied in unambiguous primary legislation, appeal to a higher law is said to be impossible. And on this footing, the courts couldn't even review a statute ordering the massacre of all infants under the age of 2 or all immigrants. Perhaps, as with Cromwell's execution, we can reassure ourselves that the question would never arise in such an extreme form. But only time will tell if there is somewhere a line which can't be crossed. It might, of course, mean revolution, and then the legal questions will, to some extent, disappear. If the king refused his royal assent to such a statute, he might well be deposed, and if judges declared it unlawful, they might well be compulsorily retired, as Cook was. The only comfort is that a written constitution would provide no better protection. Now, that alarming prospect brings me to my final reflections, you'll be pleased to hear. Under a constitutional monarchy, the law is enforced by the forces of law and order which function in the king's name, and the principal threat to this order comes from foreign enemies. Domestic law obviously can't protect us against the devastating range of powers possessed by today's potential enemies, or perhaps even by supposed friends. But extra-legal danger is also lurking on the domestic front. No legislation or written constitution can prevent a revolution if that's what the people want. I'm told that the King of Bhutan a few years ago used the absolute power of his hereditary monarchy to force his people, somewhat against their inclinations, to accept a constitutional monarchy. Right? Could equally work the other way round. If the populace thought life would be better under a charismatic authoritarian leader who had the freedom to operate outside the law, the sort of person our special advisor who wrote in the Times on Monday seems to want, they could reach a democratic decision to dispense with the legal system as we know it. Their chosen government would govern by executive decree, would constrain the courts and the forces of justice to do its will. It might employ armed agents in masks to enforce its policies outside the law. It might overpower the news media to replace truth with false propaganda and grant itself perpetual power with exemption from legal consequences. It's a pattern which we have witnessed elsewhere. And we don't need to go back to King John. The lessons are in recent history. So my final parting thought, a fairly obvious one, is that the only way to forestall such an outcome is by creating a general awareness through education that if constitutional government is weighed in the balance against despotism, the former, even if creaky and comparatively inefficient, is the more beneficial option for everyone except the profiteers. Now, we used to take that for granted, but it isn't so clear that it's still part of our national ethos. It's a simple enough message. Authoritarian government is irreversible. Once people realise that the utopia they envisaged is not going to materialise, or discover that the successors in office to the demagogue they fell for are less attractive, or even positively evil, it's always too late. And there's no easy means of return. Despotism people must understand, would remove any protections people have for their assets, their employment, their family life, and their personal freedom. And I suppose the turning point might come if and when social changes result in a substantial part of the electorate having no assets, no employment, and no family life worth protecting. And one can only hope that if we ever do enter that dangerous scene, some memory of what our lawyers and judges strove for in the past and why will be remembered with sufficient clarity to draw us back from the brink. We've been through rocky times before in the past, centuries ago, but the rule of law has in the end always triumphed. Andrew Amos regarded constitutional history as an essential part of university legal education, when it began 200 years ago, it's been stifled in this country by accusations that it represented uncritical Whiggism. I'm a bit of a Whiggist myself. I think there's a lot of truth in it. And I suggest we could best remember Amos's achievement by reinstating it. Thank you for listening.
Thank you, John. Extraordinarily powerful words. I go back in my mind to the late 70s and early 80s when I was a student, and I would have found it almost unimaginable that you could deliver such a lecture, and I think you have concentrated our minds. The mere fact that you are addressing these issues, I think, is just gives this an added significance and weight. I think we're all very aware of what it is you are saying, and I, on behalf of everyone, just thank you so very warmly for having the courage actually to open that door and force us to think about these issues. It's not easy. It's much easier to run away from such matters and take refuge in safer places. So personally, I thank you very, very deeply for that. You have not disappointed us in any way. I was taking copious notes. You remind us really in your words of who we are and from whence we came, and the incredible significance of digging back. I just did not appreciate. I was sitting with David Ibbotson and John Baker before this lecture began, recalling how sort of irrelevant Roman law and English legal history seemed to be when you were 18 years old. And then as you get older and you become more experienced in life, you come to understand the magic of the work that you've been doing, John, for your whole life, and that you've shared with us, and David Ibbotson and others have shared with us, as you come to understand the extent to which, and I think Bernard and others in the room will share the sense that we sort of go round and round in history. Nothing is actually new. You cited the past is never dead. It reminded me, of course, of William Faulkner's great line, the past is never dead, it's not even the past. And that, I think, is the magic of your words this evening. I think on behalf of all of us who are here this evening, I express the deepest thanks to you for taking the time to be with us again. You were here 50 years ago. I hope you'll be here with us many times again in the future. This is many ways your spiritual home. Please join me in thanking John Baker.